Good afternoon, everyone. I'm Barb Grandjean. I'm a partner in the Denver office of Husch Blackwell in the labor and employment practice with an emphasis in healthcare. Thank you for joining us for what I think will be the last Colorado webinar for 2020 in the labor and employment space. And before we begin, there are a few housekeeping items I need to cover with you. At the bottom of your audience console, there are application icons that you can use during our program today. There's a PDF of our presentation in the resources folder. This program has been approved for HR and legal education hours. So to report those hours, you need to click on the CEU icon at the bottom of the screen. And a certificate of attendance, including the necessary course numbers, will be emailed to you tomorrow, along with a recording of our presentation that you can watch again, because I know you're going to want to, or share with others. Toward the end of the program, please be sure to complete our short survey. We use your feedback to plan future programs and also to, improve. We're always looking for opportunities to improve. And this is it for the housekeeping items. And so we are excited to talk to you today about making sense of the Maelstrom. And I have to say that I didn't know what that meant. And so if any of you don't know, I'll let my partner, Chris Otley, tell you when he gets to his part of the presentation. But joining me today are Chris and Ashley Jordan, partners in the Denver office in the labor and employment space as well. So with that, I am going to give the first presentation, and I'm going to start with the Healthy Families and Workplaces Act. So we have spoken on the HFWA, Healthy Families and Workplaces Act, several different times this year, and I was hoping for some perfect clarity by the time we got to this December program, but I still don't think we're quite there yet on HFWA. So let me go through where I think the current state is, and then I do have a few observations of things that I think will be a little bit complicated when the calendar turns to January of next year. And due to technology issues on my end, I'm going to be the person that says, next slide, please, Shana, during my program. So let's go to my next slide, please. So as many of you know, or hopefully all of you know, HFWA went into effect on July 14th of 2020, and it required all employers in Colorado to provide all employees in Colorado with paid sick leave related to the COVID-19 pandemic. If this information that I'm just sharing now is new to you, you probably should call your lawyer. And since 2020 is almost over, thank goodness, this presentation is going to focus exclusively on what's coming in 2021. Next slide, please. So effective January 1st of 2021, most employers are going to be obligated to allow employees to accrue and use what I'm calling regular paid sick leave. This regular paid sick leave is going to be a yearly or an annual requirement, and it's a continuing obligation now year to year for Colorado employers. The year that we're talking about is presumed to be a calendar year unless you specify otherwise in a written policy. So if you're going to use some other benefits year, you need to make sure that you are putting that in your policy about this. Next slide. The other thing that we're going to start seeing, the second component to the 2021 and forward HFWA, is this public health emergency paid sick leave. And so what I'm trying to do in this presentation is compare and contrast regular and public health emergency paid sick leave. So for the PHE paid sick leave, it sort of springs into effect when a public health emergency is declared. That a public health emergency, according to the law, is an act of bioterrorism, a pandemic influenza, or an epidemic caused by a novel and highly infectious agent for which an emergency is declared by a federal, state, or local health agency or the governor, or a highly infectious illness or agent with epidemic or pandemic potential for which a disaster emergency is declared by the governor. So clearly, as we sit here today, we are in a public health emergency. This type of leave, unlike the regular paid sick leave, is paid or available only once during the entirety of a public health emergency. So that would mean that if there is a public health emergency declared, it could continue over a number of years even, but there's only a one-time payment required for this public health emergency. This is true even if the public health emergency is extended or amended or restated. So hopefully we don't get in a pattern of having numerous different public health emergencies as we go forward, but it is important to recognize this is just one time per public emergency. I fully expect that we'll still be in a public health emergency come January 1. And I think that's what's going to complicate this paid sick leave structure that Colorado has put into place. I have had several employers ask about whether the paid sick leave that they've been paying in 2020, whether it's under state or federal law, if that can be counted toward the public health emergency in the event we're still in the same emergency that continues from 2020 to 2021. And the rules are silent on that, but I think the answer is probably no, because it's my understanding that this is really intended to be a new obligation, and the fact that you've had to pay sick leave out during 2020 isn't going to count as a credit toward what you need to start having available in 2021. Next slide, please. So this slide compares the amount of paid sick leave that's required either for the regular or for the public health emergency. So the regular paid sick leave is something that's going to accrue as your employees work, unless you choose to front load it for your employees. So it accrues at a rate of 1 hour for 30 hours worked, up to a maximum of 48. And that's true for all of your employees. Your exempt people who work on a salary basis are presumed to work 40 hours a week for purposes of accrual, even if they work a lot more. Your non-exempt employees accrue based on the regular and the overtime hours that they work. So you could conceivably have a part-time employee, a non-exempt employee who works a lot of overtime, get to that 48 accrual cap faster than your exempt employee. You have to allow your employees to carry over up to 48 hours year to year. And so what that means is that you have a part-time employee who may accrue the 48 on a more slow basis, or maybe don't get to the full 48 in year one. But if they're allowed to carry it over and they're not using it, they could conceivably end up with a bank of 48 hours available to them on a go-forward basis. There's no cash value to the paid sick leave. So if someone leaves, you don't have to pay it out. You could, but you don't have to. And that's one of the complicating factors if you're going to try to embed the paid sick leave into your time off policy, paid time off. On the public health emergency side, the public health emergency paid sick leave does not accrue. It's described as being a supplemental leave that has to be made immediately available upon declaration of a public health emergency. The amount that has to be made available varies. If you have a full-time employee, it has to be up to 80 hours. If you have someone who's less than a full-time 40-hour employee, then there are ways to calculate what you have to provide, and it generally comes down to a 14-day average of the hours that they work. As I mentioned, this can only be used once during the entirety of the public health emergency, and it also has no cash value. When I talk about up to 80 hours, the language there relates to this idea that if you have someone who is already accrued regular paid sick leave, you can subtract that from the 80, for example, and you would only have to provide supplemental leave as a top up to whatever has been accrued on the regular paid leave side. So next slide, please. Uses for paid sick leave. I know this is a dense slide and it'll be a takeaway for you, but essentially there's a lot of overlap in the way that the regular and the public health emergency paid sick leave can be used. They can both be used for illness, for diagnosis, for preventative care, obtaining preventative care. The public health emergency stuff, though, is generally related only to the public health emergency. So I think you may find situations where, the overlap is that it could be regular or it could be public health because someone has an illness that's preventing them from working, and that illness happens to be the illness that's the subject of the public health emergency. And there are some priority rules that I'll talk about a little bit later on which leave you need to allow first in the event there is an overlap. Both of these include school closures related to a public health emergency. And then on the list of items that you can use the regular for, it includes when a public official has closed the workplace. And so for those of you that are used to paying sick leave right now under the Families First Coronavirus Response Act, the federal law, that's going to be a shift for you. Next slide. The pay rate for both of the types of paid sick leave is the same. And it says that it's the same rate with the same benefits, including health benefits, that the employee normally earns during hours worked. It specifically excludes overtime, bonuses, or holiday pay. But where I think it gets a little tricky is it refers to non-hourly pay that is included in the regular rate that you would use for calculating overtime for someone. It refers to the comps rule on regular rate. And the regular rate, as defined in the comps rule, includes some additional items like minimum wage tip credits, non-discretionary bonuses, production bonuses. And so I think what this means is that if you have someone that says, I need to take sick leave and I'm going to miss my next 3 shifts, if that person would have received production bonuses for working those 3 shifts, then that needs to be included in the rate of pay that you are giving them for the sick leave that they'll be taking. So I think that's a complication that we're going to have to sort out as this goes along, but I did want to point that out for you. Next slide, please. So in order to figure out how much paid sick leave your employee can take, you need to figure out whether they have a regular schedule or if they have a variable schedule. So it's the number of hours that the employee is reasonably anticipated to have worked during the period of leave. So if I am saying I need the next week off for paid sick leave, if I have a regular schedule, that's how much sick leave you're paying me. If I'm already on the schedule and you're going to have to take me off, you would pay me whatever you had planned on having me work. And if my schedule is that variable, you're going to be looking at an average of hours worked during the most recent month of work in order to figure out how much paid sick leave you have to pay. It can be taken in hourly increments. I don't think that the employer can say it has to be taken in daily increments. The way I read the rule, hourly is the largest. And if you don't specify, the employee can actually take leave on 6-minute increments. And I don't know what an employee could accomplish in 6 minutes, but I would suggest that you should make sure that your written policy specifies that hourly increments are the smallest increment that can be used by your employees when they need to take paid sick leave. Unless you front load it, regular paid sick leave can only be used once it's accrued. And again, the public health emergency paid sick leave can be taken if it's needed immediately upon declaration of a public health emergency. Next slide. So notice for the 2 types of leave are different, but essentially pretty similar. And the notice and documentation provisions of this law concern me because I think they're very, very employee favorable. And I think employers are going to have to figure out how to balance these employee favorable provisions with the idea that sometimes our employees don't do what they say they're doing. And so I think the division prepares these rules on the assumption that all employees behave at all times. So if the rule doesn't say if someone has a need for unforeseeable sick leave, what you have to do. So I would say that that defaults to the standard, which is that they need to give you notice if it's unforeseeable, but it says you can specify how you would like to receive notice, but the employee is essentially able to give you notice in any way that effectively notifies the employer. And they refer to telephone, texting, email. And so if you have a policy that specifies how people need to give you notice, you're going to want to think about that and think about whether you can make the argument that that is the only way that you are effectively notified. If the need for leave is foreseeable under either one of these, so under the regular paid sick leave, let's say I have a regular series of doctor's appointments, the employee should be making a good faith effort to provide advance notice to the employer of those things, a reasonable effort to schedule it at a time that won't disrupt the employer's operations, and if the employee doesn't give you the advance notice or doesn't comply with a notice policy, you still have to give them the paid leave. You can't deny the paid leave because they didn't comply with your notice requirement. On the public health emergency pay side, it specifies that they need to give you notice that they're taking leave related to the public health emergency as soon as practicable, or so long as the place of business is not closed. We go to the next slide, documentation. This goes along with a notice where I think it's very employee favorable and potentially problematic for employers. According to the rules, you are not permitted to request documentation for paid sick leave for someone who's taking regular paid sick leave unless they're gone for 4 or more consecutive days, and those would be days that the employee was supposed to have been working. After that, you can seek limited documentation, and there's a procedure that if you get documentation that you're not satisfied with, that you can ask the employee to fix that documentation. I refer you to the rules themselves for the types of documentation you can request, depending on whether it's a sick or a safe leave, a leave related to a domestic assault, for example. That's a little more detailed than we have time to cover today. On the public health emergency side, the rules say that you can't request any documentation. And so I've been trying to think of how employers can protect themselves in light of this. Because it seems to me that an employee could just call you up and say, you know what, I don't feel well. I think I might have COVID. I'm going to go get checked and I'm taking the day off. And if we can't require documentation, I'm not sure how we're going to be able to prevent abuse. So one thing I've been thinking about, and I encourage you to think about and talk with your payroll providers about, somebody has to identify the leave that's being taken as paid sick leave. You as the employer are obligated to track the paid sick leave that's being accrued and used by your employees. And so someone needs to be keeping a record. And so in the payroll systems that you're using, maybe what you're doing is adding a code for the employee to designate that this time that they're taking off is a time that qualifies under HFWA. So they're just simply designating their time in the system. And then presumably your system has some sort of a certification or verification that says this at the time I'm entering is true and correct and full and accurate. And so maybe that's the way to get a representation from an employee that they are taking the leave for an appropriate purpose. And then the rules do say that you can discipline an employee who is taking the paid sick leave for an inappropriate purpose. Next slide. Priority, I mentioned this earlier. The employees are allowed to use both regular and public health emergency paid sick leave during the pendency of a public health emergency, depending on which type of leave the need qualifies for. So example one might be, I need a surgery and I'm taking regular paid sick leave for that, but then I later get COVID and I'm using my public health emergency paid leave for that. In the instances when the need may qualify under both, so I'm ill and I'm seeking a diagnosis and I can't work, that falls under the regular paid sick leave. But if my illness is because of the public health emergency, then that's covered under the PHE sick leave, and we have to allow the employees to use the PHE sick leave before they use the regular sick leave in that circumstance. The third bullet point on here is the other piece of uncertainty that I think we're still dealing with. The rules specify that employees continue to accrue regular paid sick leave during a public health emergency. And so remember, they only accrue the sick leave if they're working. But I think there could be a scenario where, let's say a public health emergency is declared 1/1/21. There's no regular paid sick leave that's been accrued at that point. You have someone who actually gets COVID and needs to take the 80 hours of the supplemental public health emergency pay. And when they come back, they start working. And for every 30 hours they work, they earn an hour toward their regular paid sick leave. So I think you could conceivably have a situation, particularly in 2021, where someone uses 80 hours and then accrues another 48 for regular that they can use for regular paid sick leave, and they can carry that over into the following year. Next slide. We are permitted to use an existing PTO policy to cover off the responsibilities under HFWA for paid sick leave. You need to tell the employees before they make a request for leave that that's your plan, that you're going to use the PTO policy. And then the PTO has to have all of the same features that HFWA requires for paid sick leave. And that includes the same accrual rates, the pay rates that have to be the same, You can't have any retaliation for people taking the PTO if you're going to use it for HIFWA. So you just have to be really conscious of the details of your PTO policy. And what I'm finding is employers that maybe have accrual rates that are out of whack in their PTO plan compared to what you need to do in the HIFWA. Maybe they have a waiting period in the PTO plan for new employees, and you can't do that under HIFWA. I think there are also going to be some circumstances where maybe the pay rates in your PTO plan are not the same as what you need to be paying under HIFWA. Also, the rules specify that if you do this and someone uses all their PTO and takes a great vacation to Hawaii and then comes back and gets COVID, you're going to need to supplement the public health emergency paid leave. If they take that vacation to Hawaii and come back and need a surgery, then you don't have to give them any more regular paid sick leave. Next slide. So again, as I mentioned, as with many of these pay statutes, you can't retaliate against someone who uses the complaint, uses the leave, files a complaint, cooperates in an investigation. That's pretty standard. You can't use any paid sick leave days toward discipline, discharge, demotion. Again, I think that's a question. If you can't ask for documentation, how are you going to know? I guess the employee has to tell you, again, for tracking purposes, but I think that's a complication. If you have a no-fault attendance system, you're going to need to consider making adjustments. You do need to provide written notice to the employees of HIFWA as well as displaying a poster, and I think you could satisfy that by handing them a poster and posting a poster. They can request from you monthly or whenever they need HIFWA leave what their current balance is in terms of both the PHE, if we're in a public health emergency, and regular paid sick leave so that they know how much they have available to them and how much they've used. I know some employers are planning to make this information available on an employee portal so the employees can look that up whenever they want. And then you do have to retain the records for this paid sick leave for 2 years. Next slide. So let me wrap this up so I'm not taking too much time. Finally then, remedies, the rules are clear that paid sick leave equals wages. Anytime we're dealing with a claim for unpaid wages, there are risks of penalties and fines, including attorney's fees, being tacked on top of the unpaid wages. If an employee loses their job as a result of, for example, unfair retaliation under HIFWA, the division can order, or one of their remedies actually is that they can be reinstated. You can be ordered to take them back and pay their back pay, or if you can't take them back or they won't come back, there might be a front pay remedy. You might be paying fines and penalties to the division, and you might also get an order telling you to stop violating HIFWA, however you're doing that. So then next slide. Finally, I've been trying to include this in my presentations. It seems like the division is constantly providing new guidance and updated guidance. And so as it stands right now, this slide is the reference for you for the currently existing guidance that relates to HIFWA obligations for 2020 and forward. So you should take a look at this if you have any questions, or certainly feel free to contact your lawyer or contact us. So with that, I will turn the presentation over to my partner, Ashley, who's also going to talk about paid sick leave, but in a different context.
Thank you, Barb, and good afternoon, everyone. I am here to provide an overview on the vote just last month to approve a paid medical and family leave program in Colorado. And I stress that it's an overview because it's a very new program. There are more questions and answers at this point, but we thought that it would be worthwhile to at least give you a primer and just some things to think about because there is a good bit of time before it actually goes into effect. But as we all know, time flies by quickly, and so there are definitely some things to go ahead and be thinking about now. So this program was part of Proposition 118. It passed last month. There have been various versions of this bill that had been proposed before without success. And actually, this program was on the November ballot only after the program failed to pass during the 2020 legislative session in the state. And it secured enough signatures that it was resurrected in time to be on the ballot in November. What it does is it creates a state-run paid leave insurance benefit for Colorado employees if they work for an employer who has at least 10 employees. So for employers who are very small, 9 or less, this program does not apply. There are only a handful of states around the country who have a program like this. So we're in a small company. And like I said, there are many unanswered questions because this is very new. But what we expect is that the Colorado Department of Labor is going to address those questions over at least the next year or two before payroll tax is implicated, and I'll get through the nuances of that in a second. What I would expect is that the three of us are going to be issuing various legal alerts and updates through email and on our website as those questions are answered so that you have the most up-to-date information. And I would just stress and emphasize that you be on the lookout for those because it's going to be very helpful to get some more guidance. Right now, things are quite vague. The way it works is that the Colorado Department of Labor is going to administer this program through a newly created division. And that division is going to be responsible for collecting the premiums, administering the program, determining and reviewing claims, and for permitting appeals of denied claims. So what I anticipate is going to be run fairly similar to the way the unemployment division runs. The good news is for employers, you don't have to calculate what the benefit would be. That would be something that the employee would get directly from the division. And it's quite a complicated process. So you can refer those questions directly to the division if an employee asks, what kind of benefit would I be entitled to? Both employers and employees will equally pay funds to fund the program, and the payments are going to begin in about 2 years from now on January 1st, 2023. And then the benefits would be available to employees under this program beginning January 1st of 2024. And the benefits can be used for up to 12 weeks in a calendar year. And if the situation involves pregnancy or childbirth complications, there is an option for an additional 4 weeks of paid leave. So if an employee meets certain eligibility requirements, and I'll get to that in the next slide, but if those requirements are met, they may take family and medical leave and receive the benefits for one of the reasons stated on this slide. And they may look like fairly familiar conditions because they in large part mirror federal FMLA conditions and situations. The eligibility requirements for the Colorado paid family and medical leave are that the employee has to have worked at least 180 days for the employer, so approximately 6 months, and the employee must have earned at least $2,500 in wages. And I've already stated that employees, even if they've met those thresholds, but if the employer does not have at least 10 employees, then the employee is not eligible. So let me get back to, So I thought what would be most helpful to you all is to spend most of my time talking about questions that we're already getting and answer those to the best of my ability based on the regs that have come out at this time. Obviously, we're still waiting on some guidance to navigate us through this process, but there are some questions that can be answered that I think would be useful to you all if you haven't had a chance to read the law that has come out. So the first question, and I think it's a pretty natural one, is how does this paid family and medical leave in Colorado work in conjunction with the federal FMLA? So what employers can require in Colorado is they can require leave to be taken under this program to run concurrently with leave taken pursuant to the federal FMLA. So you may recall that the federal FMLA requires job protection, but it doesn't have a pay mechanism for individuals employed by employers who have 50 or more employees. So the number of employees is different. The federal FMLA doesn't include a pay component, but the two can work in conjunction with each other and can run concurrently. In Colorado, the initiative guarantees that an employee cannot be fired while on leave if they've been on the job for at least 180 days. And just like the federal FMLA, an employee has to be restored to an equivalent job upon returning from leave as a general rule. There's obviously some caveats to that, just like in the federal FMLA, but those two, the job protection factors are quite similar. What about other policies that you may have with respect to leave? We've gotten a lot of questions about that. Like if we already provide sick leave or PTO, how does this play into that? And the answer is that you as the employer cannot require the employee to use or exhaust any accrued vacation time or sick leave or other paid time off prior to or while receiving the paid family and medical leave under this new program. And so it's up to the employee on whether or not they want to use this new program first or after their other leave is exhausted. And one thing to note is that the employees cannot lose their health insurance while they're out on the Colorado family and medical paid leave. But you can require them to continue paying their portion of the policy or the premiums while they're on leave. I've gotten some questions about intermittent leave, and that I feel that will probably play out a little bit more, maybe in some frequently asked questions that the Department of Labor issues, because I think it's ripe for confusion, to say the least. But what has been said so far is that intermittent leave is going to be permitted, or the division is going to allow it to be permitted by an employee if the employer typically provides for intermittent leave in its policies. So that's obviously a little ambiguous, but I think what it shows is that the idea is that there's not going to be a ban on intermittent leave, and the employer is probably going to have to show a real reason why the intermittent leave would not work. And particularly if intermittent leave is already allowed pursuant to other policies that are applicable to the employer, then the employer is not going to have a very strong argument on that front. Next question. It has to do with how do these benefits work? Is there a cap on benefits? So just kind of take a step back here. The employers and the employees are each going to pay 50% of the tax. So it's definitely an equal fraction for both of them. And then, like I said, beginning January 1st, 2023, in 2 years, the payroll premiums are going to start. And the way it's going to work is that they're going to be paid into a state treasury fund. And the purpose is obviously to fund for the benefits of the program. The initial premium is 0.9% of wages per employee. And that percentage is going to apply for the calendar year of 2023 and 2024. So from January 1st of 23 to December 31st of 2024. There is obviously a great amount of uncertainty about what happens starting January 1st of 2025. Not surprisingly, the Colorado Department of Labor has not gotten that far and has just said that going forward after 2024, that the new division that's administering the program will address future premium amounts. There is a little bit of certainty on that front in that there is, as of now, a current reg that states that no premium shall exceed 1.2% of wages per employee. So there is some wiggle room even now for that premium to go up. Right now, it's the reg states that it shouldn't go up past 1.2%, but that's going to remain to be seen. We're talking about 3 years from now. Then a related question is, well, what can an employee expect in terms of benefits? If my employees come to me and they start seeing, news about this program, on the internet or talked about on the news, and they come and ask, what benefits are going to be available to us, employers are wanting a general understanding of what that means. And the answer is that, and it's not surprising, is that it's actually pretty complicated. What the division is going to have to do at the onset is calculate the state's average weekly rate, average weekly wage rate as an initial matter. And that's important because it's used as a threshold. The employee is going to receive paid leave amounting to 90% of their average weekly rate for their portion of the wages that's equal to or less than that 50% of the state weekly wage rate. And I know that's complicated. And then on top of that, the employee can receive 50% of the portion of their wages which exceed the state average weekly wage rate. So again, it's very complicated. I think employees are going to have, in large part, a hard time kind of understanding what their benefit could be. And right now, we're talking about it in a vacuum because we don't know what the state is going to set as the weekly wage rate. There are some maximums. So the maximum benefit is 90% of the state average weekly wage rate. And in 2024, there is a stated maximum of $1,100 per week. So again, there's a lot of numbers in there. There's some unknowns because the weekly wage rate has obviously not been calculated yet and would have to be calculated much closer to 2024. And there is a maximum for the year in 2024. So it gives a little bit of guidance at least as to what your absolute maximum which is $1,100 a week, but obviously not thinking that every employee is going to be able to reach that maximum. Some employers have said, what if we have our own private plan? Do we have to have both? And the answer is no. You don't, but there is a caveat that you need to be really careful. So an employer can apply, and I do stress that you have to apply to use a private plan and substitute out of this program. But there are requirements for this, and I anticipate that there will be much more detailed requirements as time goes on. But the bottom line is that if you're already providing hefty benefits to your employees, and they are better than what this program is advocating for, then you are likely going to be able to opt out. But you have to be really careful because there are some very serious fines if you opt out, and you shouldn't have. And right now they're stating that the fine could be up to $500 per violation, not per employee. Not, as a one-time, hey, I messed up. It's $500 per violation. So as I'm sure you can imagine, that could really add up quickly. And you just want to be extremely careful that by the time you make a decision to opt out, and that there are more detailed regs on the program, that you fall in the category of being able to substitute out, and that you've applied appropriately to be able to do so. And then, obviously employers are asking, well, what can we do now, or what should we be doing now? This seems like it's not going to take effect for so long. Is there anything we really need to go ahead and start doing now? And I think there are some things to be doing now, and then there's some things that you put on a list of things that you want to make sure that you don't forget about later as 2023 especially starts getting closer. I think right now, one of the best things you can do is start thinking about how you're going to internally work through this process, what procedures you're going to implement within your company in order to implement this new payroll tax, and kind of who's going to be in charge of that, and developing the process for making sure that that payroll tax is taken. The division is working on a poster, and so this will be another poster to add to your collection. But when that's available, you obviously want to be posting that notice in the workplace, but it's certainly not available at this time. I think another thing to think about is you can go ahead and start figuring out what your communication plan is going to be about this. It's up to the employer to communicate to the employees about this program. And it's obviously easy when you have a new employee and you can go through it during the onboarding process. But for existing employees, you also need to be able to communicate to that group of individuals what they need to know, because they're going to be having extra withholding taken out of their paychecks, and they also need to understand that they have this benefit that's potentially available to them. And so you can be thinking about what your communication plan is, who's going to communicate it in what fashion, and perhaps get a written acknowledgement signed by employees showing that you did communicate and that they understand who to go to if they have questions. I think it's important for you to figure out internally who your point people are going to be if employees have questions. I think it's important for you to communicate to the employees that they have an obligation to let you know if they have a situation that might give rise to this program, and really just use the next couple of years, especially in this next year, going through and having those internal conversations to figure out how you're going to implement it, and then spend the next year, which would be 2022, to make sure you're communicating in the appropriate fashion and documenting where necessary. And the last thing that I would say of what employers need to do is just to stay on top of these regs and the guidance as they come out. I'm anticipating that there's going to be frequently asked question sheets that maybe are promulgated by the Department of Labor. Our law firm will certainly be issuing alerts as there are more and more guidelines issued. But I think you just need to have kind of on your radar that this is happening. It is definitely happening, and that there are going to be more guidelines coming, and that you need to make sure you're getting those, and that you're on top of them, so that you are not moving one step forward and 2 steps back, but that, as each new guideline comes out, that you're adding to your arsenal of what you need to be doing at this point to prepare your workplace for this program. And so that is a very quick overview. Like I said, there's more questions and answers right now. We will keep you abreast of those, but I want to make sure that we leave enough time in this webinar for Chris. So I am going to turn it over to him now.
Thank you, Ashley. I am Chris Otley, and I am with Husch Blackwell. I think my video is on. Maybe Ashley can give me a thumbs up if she can see me. Thank you. Okay, we're double checking on these things. So as Barb alluded to right at the very beginning, I was the one who came up with making sense of the Maelstrom, and that's partly a reflection of my my firmly held belief that big words are better than little words. A little word that makes sense of all this is just the pure chaos that has been created in the Colorado workplace laws in the last few years. And it's been created by a lot of good, well-intentioned, regulators and legislators, and recently the people of the state of Colorado. What it is really difficult to do is keep track of everything. So we thought that today's presentation was really, let's hit the high-level issues that we thought that everyone needs to be making sense of beginning January 1st. And the biggest one I think that everyone needs to be making sense of right now is the Equal Pay for Equal Work Act. Some of you have already heard me present on this before. We could literally talk about this topic for 3 hours, not 15 minutes. There's an awful lot that has happened. For those of you who attended our webinar in September, the biggest changes that have taken place are the job postings. So I am going to get into this right away. First thing that you need to understand about the Equal Pay for Equal Work Act is what was its intent. The intent of the Equal Pay for Equal Work Act is attempting to address the widely known disparities in pay between men and women. Now, the statistics that are usually promulgated with respect to that consider the aggregate pay of women and aggregate pay of men. That's not actually what the law is aimed at. Even though that makes its way into the legislative declaration, what's really this law is focused on is comparing two similarly situated individuals. And we're going to go through exactly how the law does that. The key thing for you to be aware of is the underlying assumption of the entire law. The law assumes that pay disparities with the differences between the sexes are the result of discrimination. If you work from that assumption, that's going to help you to understand and be able to explain to others in the workplace what the law requires. The law was passed in 2019. It goes into effect in about 2 weeks, January 1. It is basically a combination of discrimination law and wage law. It has more punch than discrimination law, which I'll go into a little bit, and it's also a little bit more targeted than standard, more punch than discrimination law, and it's a little bit more targeted than wage law. The key issues too is that it has fewer defenses and it applies to all size employers. So everyone just right now, don't tell me that it's going to be difficult for a small employer to come into compliance. Everyone's going to have to comply with this law beginning in a couple of weeks. There's multiple intersecting requirements between pay equity, the posting, record keeping, enforcement, prohibited questions, audits, and even some more beyond that. I'm just going to, for the next 15 minutes or so, focus on the two ones on the left here, which are pay equity and posting. So really the meat and the potatoes of the two sections of the law. The other requirements are out there, and I mentioned it to you only so that you're aware of it and not think that just listening to the next 15 minutes will answer all your questions. So let me take the time to walk you through what is the meat and potatoes of this law. And there's a key provision. It starts off right from the beginning saying an employer shall not discriminate between employees on the basis of sex by paying an employee of one sex a wage rate less than the rate paid to an employee of a different sex for substantially similar work based on the composites of skill, effort, and responsibility, with 6 exceptions: seniority, merit, earnings and quantity, geographic location, education, or travel. So let's unpack that. First, biggest question of all, is this a strict liability statute? I would love to find out that what I'm about to tell you is wrong. I think that's going to be it's going to be pretty tough for you to be able to argue going forward. Like most wage and hour law, it is in essence a strict liability scheme, which means that good faith employers who are doing their best, employers who think that they are in compliance with the law, are not going to have a defense to this law to say, well, one individual employee was paid more than another between the two. And the reason for that is because of the language of the statute itself. An employer shall not discriminate on the basis of sex by paying an employee of one sex a rate less than the other. By paying. That assumes that that difference in pay, that pay disparity, is itself an act of discrimination. So how is this law going to work out in practice? Well, first, the key thing to understand is that it's all going to be about grouping employees, figuring out who the cohorts, who are the individual employees who are doing substantially similar work. Notice that it's not equal pay for equal work. The reason why it's not equal pay for equal work is because not even the federal law provides for equal pay for equal work. The Federal Equal Pay Act, which has been in effect for decades, uses the phrase substantially equal work. Well, Colorado takes a little step back and says substantially similar. This is similar for those of you who operate in California. That's the exact same language that's used there. I anticipate this is going to be the most widely litigated issue. And I really think this is where the issue of whether two employees are being paid for substantially similar work is going to be most frequently played out in the courts. And the reason for that is that even though we kind of know what the principles are going to be, it's going to be very hard to define those principles for every single variation in the workplaces that are out there. So the three things that they look at will be, or that the course will look at, is skill, effort, responsibility. We don't have any additional guidance on what those mean. Certainly we can look to some of the cases in other states and in the federal law. Generally speaking, what I'm advising employers is use a common sense understanding of what skill, effort, and responsibility are. The key one that's going to be the differentiator most likely is going to be responsibility. So let me give you a real quick example, and it is applicable across the workforce. But for example, a chief financial officer is not someone who has the same responsibilities as, say, a chief human resources officer or the chief legal officer or the chief operations officer. Yet generally speaking, we know the CFO is more often than not paid higher than those other 3 or 4 positions that I mentioned that are also in the C-suite. So perhaps the skill levels are the same and the effort given by all those C-level suite executives are higher, but responsibilities are different. So that will be the differentiator that I anticipate most employers will be able to rely on in terms of trying to say that employees are not doing substantially similar work. Once we cross the threshold of deciding that 2 employees are doing substantially similar work, there are 6 exceptions that will apply. The first 3 come directly from the Federal Equal Pay Act. Seniority, which basically means tenure, although it perhaps could mean something a little bit more, perhaps, for example, experience outside of the company. A merit system, which will be closely related to how do you measure merit in the workplace. If you are someone who performs performance reviews on an annual basis or less, it's highly likely that's going to tie into a merit system. A system measuring quantity or quality, that might be something like a commission system or a little bit less defined of areas. Location, I think, speaks for itself. I think that's just the economic reality that employees working, for example, in the Denver metro area are generally speaking going to be paid higher than employees working in Pueblo or Grand Junction or other great places in the state of Colorado. Education also includes things like experience, and then travel is the one that I anticipate to be the least likely exception that will be invoked. The key, though, is not those 6 exceptions. The key is to understand what's not included within those 6 exceptions. What is not included is the catch-all defense that is present in the federal law and, frankly, in almost every other state law that's very similar. Under the Federal Equal Pay Act, a defense could be used, a defense that employers were able to invoke was a differential in pay based on any other factor other than sex. That is not included in the Colorado law. It was intentionally excluded from the law. When the business community was trying to provide some input on this law, when it was going through the legislature, the General Assembly, in 2019, that was specifically proposed, and it was specifically rejected. There is no question that this catch-all defense has been the most widely used defense under federal law. When I say that Colorado has the most far-reaching and most consequential equal pay law in the entire country, it is because of this omission, not because of what is included. So it's important for everyone to recognize that you cannot rely upon any of the exceptions, or you can't rely on any defense other than the 6 exceptions that I just went through. The most common answer that I provide to make sure that everyone's aware of is that, for example, if you have a sign-on bonus, if you have, for example, 10 registered nurses and you want to hire an 11th registered nurse, and to entice the registered nurse from one hospital to come to another, they decide to provide that person with a sign-on bonus. For the year in which that sign-on bonus was paid, if there is a difference between the sexes with respect to pay, that doesn't fit into one of those 6 exceptions. There may still be some other defenses to that. I don't want to say it's a per se rule. But generally speaking, that's in one area, just one of many areas that we see that we're seeing some problems with. Section 2 of the law concerns job posting, and this is where we've received the most activity lately. Under the job posting rules, which actually were pretty simple and straightforward in the statute that I summarize here on this slide, job postings have actually generated a lot of attention, particularly from the HR professionals who are on this webinar right now. These job posting responsibilities are brand new. They're somewhat unique to the state of Colorado, not completely, but primarily there's not very many laws out there that provide this, and is exceptionally detailed. One of the reasons why we're receiving so many questions about this law is not because it has the teeth of the Section 1 that I just went through. The teeth of the Section 1 is lawsuits and back pay and liquidated damages and things like that. The job posting rule actually has relatively minor enforcement mechanisms. The reason why it's garnering so much attention is that it's the micromanagement of the HR function. And generally speaking, the HR functions, such as job postings or notifying individuals of vacancies or internal promotional opportunities, doesn't exist. So between these two statutes, or two very short paragraphs, we have two sections. And I'll take the second section first, which is exactly the way the rules do it here in Colorado that were just released. And these rules here, by the way, are cited 7 CCR 1103. For every single job posting that needs to be made, employers are going to be required to provide a good faith range of salary and benefits. That has also caused a lot of consternation. What is a good faith range? A good faith range is nothing more than literally, what do you think is the minimum that this particular position would be able to be paid, and what is the maximum? And you're going to be required to list that in the job posting. We've seen some questions about, well, can't we just say $0 to $1 million or something like that? The answer is no. This has received a lot of attention. I think it's been thoroughly vetted. There needs to be a good faith estimate of the salary and benefits. Now, employers are allowed to exceed or come under that range as long as they have to, at the time of the posting, had a good faith estimate. So it's not going to be locked in stone as a collar, but nonetheless, you are going to have a reasonable discretion with respect to that. You are allowed to provide slightly less specific information with respect to bonuses, commissions, and other kinds of compensation, and also any sort of description of the benefits, such as like overtime benefits, the health and welfare type benefits, retirement benefits. Those sorts of things can be listed just in general terms. But all three categories that are listed on these slides needs to be included in the job postings. All right. Going back to the first part of this rule, the reasonable efforts to announce promotional opportunities. This is the one that's causing probably the most consternation amongst everyone who's on this call, which is A, what's a reasonable effort? I don't think that one's going to be too difficult for employers to comply with. It's basically, if you have an intranet where you post jobs, that's where you're going to be required to make job promotions available. Well, what is a promotional opportunity? A promotional opportunity is a vacancy in an existing or new position that could be considered a promotion for any current employee. When it's a promotional opportunity, the idea is that all employees are going to receive notice that there is a promotion opportunity, an opportunity for promotion that they can apply for. This promotional opportunity needs to be made available to all employees, even if they're not qualified. You are able to say, we're only going to hire people who are qualified, and here's the minimum requirements, but it is something that is going to be required for all employees to receive in the state of Colorado notice of a promotional opportunity. A big questions come up is, what about inline promotions? Let's say that you move somebody from a manager to a senior manager level. It's not as though that you had a vacancy within the org chart. You just decided the person had the experience and skills necessary. Right now, the state of Colorado Division of Labor Standards and Statistics is saying that does not qualify, that promotion is still supposed to be promoted. I think that's inconsistent with the language of the law, the statute, and the language of the rule itself. So there's a guidance document that was provided by the Division of Labor about those inline promotions. I still believe, and I'll maintain for any of my clients, that a vacancy needs to be created within the organization for this promotional rule to apply. What goes into the announcement? Same thing as the previous job postings: job title, comp, benefits, means to apply. Also, which employees must receive the notice of the job posting? The employers who must be notified of all employees. And it's stated that it's limited, as I said before, but it goes to all employees. So that means that if you have an executive vice president vacancy within the organization, that must be published all the way down to your line level employees. There are three exceptions that I think are important, and there was a little bit of pushback after the initial publication of these rules during the notice and comment period. One is if there's a compelling need because of confidentiality. So for example, the person who's an incumbent in the role doesn't know they're about to lose their position. That job posting doesn't need to be made available. If there's an automatic promotion, a little bit along the lines of what we just said, within 1 year of the person being hired. So for example, the offer letter says that you'll be eligible for promotion. And then as well, temporary employees, any sort of promotions for someone being like named an interim CEO or below, that would not be required as long as it's less than 6 months in the role. When the original rule was proposed, there was some very aggressive language with respect to the geographic limitations. Does this rule apply outside the state of Colorado? To the Division of Labor Standards and Statistics credit, they have pulled back on that rule and made it much more straightforward, which is that the rule does not apply, these promotion posting requirements do not apply to employees entirely outside of the Colorado. And then the posting of the compensation information does not apply to jobs to be performed entirely outside of Colorado or postings that were made entirely outside of Colorado. I think there's still a little bit of ambiguity in there, and I think that there's going to be some discussion and perhaps some litigation going forward about how that will take place. But needless to say, the final rule is nowhere near as expansive as what the original proposed rule was. And that was just made official just about a month ago before. So with that, it is 1 o'clock. We tried to get all this in within 1 hour. I have a reminder for a couple of things as we finish up our webinar here and we go through this. Is first, don't forget that we have HR and legal education hours, and you can report those hours. Click on the CEU icon. You're going to be receiving a certificate of attendance, which will be emailed tomorrow along with recording of our broadcast here. And finally, please complete your survey. We'd love to hear from you directly. With that, I'd like to say thank you on behalf of Ashley and Barb. We enjoyed doing these sorts of things, and we're glad that we're able to have our message heard by so many people. If you have any questions at all and follow-up, please don't hesitate to reach out to us. We certainly appreciate the, particularly from, individuals that we have not had any contact with before. We certainly appreciate the opportunity to make a connection with you. And with that, this concludes our webinar. I'd like to thank you very much.